Good morning from Hong Kong and good afternoon or good evening, depending on where you are. Thank you so much for attending our webinar on regulating social media algorithm hosted by the University of Hong Kong Faculty of Law. I'm Haochen's son. I teach intellectual property and tech law at the University of Hong Kong. So on behalf of our faculty, I wish to extend a very warm welcome. Let me speak a little bit about the reasons why our faculty decided to host this webinar. As all of you know, the proliferation of algorithm in a wide range of technologies, such as artificial intelligence and facial recognition, has been increasing day by day, and the applications of such technologies are seemingly endless in our daily life. So in this context, the stories of algorithms applying to making decisions, especially those applied by social media technologies, are becoming headline stories. And so given the novelty, scale, and opacity involved in the applications of algorithm, stakes are often increasingly high. So against this backdrop, some countries actually have adopted legal regulations. For example, China and France have enacted specific laws regulating the application of algorithms. And in the United States, legislators are considering how to legally regulate algorithms as well. Against this backdrop, we are hosting this webinar as a timely response to those critical developments. We have two panels of distinguished speakers who will examine how to regulate social media algorithm in legal and policy perspectives. I'm thrilled that our first panel will be moderated by Professor Anupam Chander. He is Scott K. Ginsburg Professor of Law and Technology at Georgetown University Law Center. He is a leading expert on the global regulation of new technologies. So let me hand it over to Professor Chander and invite him to start our first panel. Professor Chander, please.
Haochen, thank you so much for this invitation and for putting together this amazing conference. I'm very excited to hear what the panelists of this panel and the second panel after that have to say. So let me introduce the panel, which is made up of some of the smartest people and the most important voices writing in this space. So first, let me introduce Pam Samuelson, who is known to everyone in internet law, certainly in intellectual property law. She is the Richard M. Sherman Distinguished Professor of Law and Information at UC Berkeley. Professor Sun, of course, has already been introduced. He will speak after Professor Samuelson. He is a member of the University of Hong Kong Faculty of Law, as you are aware. Professor Christopher Yu is the John H. Chestnut Professor of Law, Communication, and Computer and Information Science at the University of Pennsylvania, Carey School of Law. I believe I'm legally obligated to say Carey School of Law, so I'm making sure I fulfill my legal obligations. And Woody Hartzog, Woodrow Hartzog, as is, I think, on his birth certificate, is Professor of Law and Class of 1960 Scholar at the BU School of Law, which has attracted some of the leading thinkers in this space as well. So with that, I'm delighted to have all of you here, and then delighted to turn the floor over to Professor Pam Samuelson.
Wonderful. So hi, everyone. And thank you to Professor Sun for providing me with the opportunity to participate in this event. I will now share my screen. And I want to actually say that I think that if you're interested in these mandates of transparency, Eric Goldman has written a couple of articles on this subject, and I learned quite a bit from reading his work, but it's definitely somebody who has made a big contribution. Why consider disclosure mandates these days? Well, as we know, there's a lot of dissatisfaction with social media platforms. And so policymakers all over the world have been trying to think about sort of what regulatory measures might they adopt that would reduce abuses. And the notion that social media algorithms are causing harms by facilitating extremism and terrorism and spreading misinformation and the like, those are things that cause people to start thinking about how to reduce those harms, and disclosure mandates is like one of the tools in the toolkit of regulators. And so what we see is that actually some disclosure mandates have already been imposed. Legislatures in Florida, Texas, and California have done them. Now, all three of those are actually under First Amendment challenges. And I think, Christopher, you will talk a little bit more about some of the First Amendment issues. But I just mentioned that for the most part, those regulations are not aimed at algorithms, but more about sort of trying to force the social media to articulate what their editorial decision-making about content moderation is about. And yet Texas law actually requires that social media companies disclose search, ranking, and other algorithms that determine results on their platforms. And the Texas law also requires biennial transparency reports, and the Digital Services Act, which the European Union has adopted, imposes many new responsibilities, including some mandatory disclosure rules. So it's happening. Now, there are lots of benefits to disclosure mandates. They don't dictate generally what choices firms have to make. You know, you have some freedom. You can do it this way, you can do it that way. But as long as you sort of disclose what you are doing, and then of course they generate information so that others who are affected by the decisions can know something more than they knew prior to the disclosure mandate. And of course, once the information exists and is disclosed, regulators can make decisions about whether firms are complying and hold them accountable. And that's certainly one of the goals of the effort. And they also can nudge firms to adopt policies that regulators think are more beneficial than the ones that they might be doing without the disclosure mandate. And for regulators, it's generally less costly to require some disclosure than to do direct regulation. Now, that isn't to say that they have all kinds of only good things about them. There are lots of downsides too, because they can impose a lot of costs on firms, that can create barriers to entry. They can also discourage entry or encourage exit. The question about sort of what information will really be useful and getting just the information that's going to be useful and not more information or less information, that can be a challenge. And of course, as Professor Sun will tell you very soon, there are going to be some resistance on trade secrecy grounds. And Professor Yu will be talking about freedom of speech and freedom of press challenges to these kinds of rules. But I want to take a little bit more practical focus in the rest of my remarks. So if you're going to design a disclosure regime, have to make a whole bunch of decisions about the how to configure the regime. So I'm going to go quickly through some of these slides to talk about it. So first thing is who gets to design the disclosure mandate. What we have now is Texas and Florida and California issuing mandates, but on a state-by-state basis, that doesn't make any sense. It would obviously be desirable if it could be done on an international basis, but there's no way there's consensus on that either. So at least you got to hope that there's a way to achieve it at a national level. But can you rely on the US Congress these days? They have got lots of things on their agenda, and this isn't very high on it. But maybe President Biden could think about an executive order as a way of at least moving this along. And of course, you're going to have an agency to do the regulation. So the most obvious one might seem to be the Federal Communications Commission, but it doesn't have any experience regulating internet platforms, and it's unclear that it has statutory authority to do this. Federal Trade Commission does have some experience with regulating internet platform companies, but does it have the authority to impose disclosure mandates? I'm not so sure. And the NTIA, the National Telecommunications and Information Administration, it's another agency, but it hasn't done this kind of regulation in the past. So there's a question out there about sort of who would be doing it. And then the next question is, what do you disclose? Now, all computer programs and all social media platforms and all platforms of all sort are embodiments of algorithms. So which algorithms are we going to talk about? Which ones need to be disclosed? And if it's only some kind, how do you define that? Is it recommendation algorithms? And if some recommendation algorithms are beneficial, how do you make a distinction between those that are useful, are beneficial, and those that are harmful? I'm not sure it's so easy to do. A next question is who is it that these disclosure requirements apply to? So the Texas and Florida laws talk about large platforms, sort of define social media platforms in a particular way. But you know, anybody who's going to try to do these mandates is going to have to make some decisions about sort of what to include and what to exclude. And you know, is Wikipedia or Internet Archive going to be disclosing? And is that a good idea? Is that really needed? Or are we looking only for those that have kind of hate speech and the like? I'm not sure, but certainly you have to make decisions about these things. Similarly, when and how often must algorithms be disclosed? And do you do it ex ante, so that before you launch the algorithm, you have to say something about it, or ex post? Do you do it annually? Do you do it quarterly? Or whenever the algorithm is revised? How much detail to require? As you see from my slides, there are quite a few decisions that you have to make. And you have to decide if there's going to be non-compliance. What are the penalties that you want to impose? Do you do different levels of fine based on failure to disclose altogether or partial compliance? I don't know exactly, but it seems to me that these are all questions that people need to address. And then, what is the cost-benefit analysis of a disclosure, algorithmic disclosure mandate? It seems to me that the costs would probably be very substantial for the firms, and again, depending a little bit on how much they have to disclose and how often. Got to have some concern about whether it's going to slow down innovation, because the mandate would impose those costs. Legal challenges to those mandates would certainly be raised in the United States, and firms will probably want to try to evade it. And it's just one of those things where if you do the cost-benefit analysis, I'm not really sure that the disclosure mandate by a regulatory agency is really such a good idea, and we have to think about whether the goal of reducing harms can be achieved in a less costly and less burdensome way. Now, one way that things happen in the United States, regulation, is through litigation. So one way to get disclosure of harmful algorithms would be for plaintiffs to bring a lawsuit saying, hey, this social media platform caused some recommendations to be made that caused some specific harms to me. And if I can get past the motion to dismiss, discovery could reveal what algorithms were used and the extent to which the algorithms contributed to the harms. And one of the things that litigation can do is discourage firms from taking risks if they could get sued for damages if they have harmful recommendation algorithms. The United States Section 230 defenses are gonna test this. The Supreme Court has 2 cases now, and I'll just briefly mention them. But for those of you who are not Section 230 experts, let me just mention what it says. So no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information content provided by another content provider. The cases are the Gonzalez versus Google and Twitter versus Tomah case. They're very similar claims against the social media platforms. The Gonzalez case is going to review the Ninth Circuit's dismissal of Gonzalez's claim against Google under Section 230 because Gonzalez alleges that the ISIS videos on YouTube were being recommended to people that they then got radicalized and engaged in terrorist activity conduct that actually resulted in the death of the young woman who was murdered in Paris. And so the question that the court's going to have to address is whether recommendation algorithms are, as the Ninth Circuit said, merely neutral tools that facilitate users' access to third-party content that they might be interested in, or does algorithmic recommendation of these videos constitute speech by the platform so that Google, in fact, is speaking through the recommendation. And that's the question that the court will have to address in about a month. Twitter versus Tomah, very similar, except that there was no, the trial court in that case didn't decide on a Section 230 defense, even though Twitter raised it. Instead, the Ninth Circuit said that Tomah had adequately pled an anti-terrorism claim against Twitter, and the Supreme Court's going to have to decide how much of a causal nexus might there be between the ISIS tweets and the victim's murder, and how substantial does the assistance to terrorists have to be, and what kind of knowledge about the ISIS tweets might be necessary. So I will just say it's not easy to figure out what the Supreme Court will do in this particular case, but I think that we can count on Justice Thomas to rule against both Twitter and Google. He's really hostile, so there's that. But I think the Tomah case is probably the easier one to to resolve. I think the Solicitor General's brief about aiding and abetting requires a more substantial assistance than Twitter provided, and also that there has to be some knowledge about the sort of the material contribution to terrorist conduct. And if the court does that, they could actually get out of the whole thing by the Gonzalez case by saying, I don't have to reach the Section 230 defense because the claims against Google are substantially the same as in the Tomah case. But of course, the other thing is that the Supreme Court could uphold Google's Section 230 defense, and then it could reverse in Tomah and send it back to the lower court for a finding on this Section 230 defense. So I actually think that this is going to be a tough thing for the Supreme Court to resolve, but I think that those of us who've been studying Section 230 think that this idea that some of the amici and Gonzalez lawyers are saying is, oh, Section 230 is only about this kind of really passive stuff. But if you look at the definition of interactive computer service, it makes reference to filtering, screening, disallowing, choosing, picking, digesting, displaying, searching, organizing, and reorganizing content. And if that's true, then it seems to me that the recommendation algorithm might very well fall within the definition, and therefore, Supreme Court could say, hey, talk to Congress, but we have to rule in favor of this one, of this defense in this particular case. Some of the amici are trying to say, oh, this kind of algorithm recommendation is okay, but this kind isn't. I don't think that's a really feasible thing to do. So we'll see, but that's where I'm going. Anyway, at a high level of generality, I think we can all say that social media platforms are a little too powerful and a little more regulation might be desirable. Some disclosure mandates are probably a good idea. So, being forced to disclose what your terms of service are or your privacy policy, that's something that is a disclosure policy, which I think might make some sense. But as you can see, I think that mandating disclosure of social media algorithms just is going to be a difficult design problem. Of course, social media platforms may not be the only ones who abuse it, so there's got to be some more general framework for thinking about algorithmic recommendations that cause harm. And with that, I would leave it to my colleagues to follow on with other thoughts.
Great. Thank you so much, Pam. And thank you so much for a wonderful description of the challenges of imposing disclosure mandates on algorithms, on social media algorithms in particular. So thank you. And thank you also for touching upon Gonzalez and Tomah, the two critical cases that the Supreme Court will decide on this spring. I believe the oral argument is scheduled for February 2021. And so for those who are following this, you may well want to tune into that oral argument. I think that's going to be a really blockbuster case in particular. So let me turn the microphone over to Professor Haochen's son.
Thank you, Anupam. I also want to thank Professor Samuelson for the fabulous talk. I always find it is a daunting task to speak after Professor Samuelson. Today, I found that she has already covered quite a lot of things that I wish to share in my talk. So, but anyway, as you can see from the title of my talk, I'm gonna, my talk is designed to provide a kind of a new legal and policy perspective in the regulation of social media algorithm. I called it the right to know algorithm. So this will be presented as a new legal and policy ground for the regulation of social media algorithm. And so as many of you have already know, most of algorithms, in particular social media algorithms, are designed and applied in black box manners. So that's why some scholars say that we now live in a black box society, right? Okay. So this is the technical element of the design of algorithms. But legally, I would say we have a whole range of laws, in particular intellectual property laws, protecting algorithms as trade secrets. So that's another reason why algorithms are, treated as black boxes, and this is a sort of legal reason why we are kind of, increasingly living in a black box society, because the algorithms are protected as trade secrets, and companies are not obligated to disclose them, as Professor Samuelson has already pointed out. So I'm going to talk a little bit more about why algorithms, in particular social media algorithm, can be protected as trade secrets first, and then move on to talk about the new legal right to know algorithm. So first of all, standards for trade secret protection. These standards varies across countries, but in general, we have three elements of protection standards. First of all, a piece of protectable information should have commercial value. It is valuable for rights holder of the information. And secondly, the information is known only to a limited group of persons. So this is the confidentiality element of the information. And thirdly, trade secret law normally requires that rights holders should have taken reasonable measures to keep the confidentiality of the information concerned. So you can see that obviously social media algorithms are of very high commercial value, right? So for example, I'm pretty sure that the most valuable trade secret now should be the Google's search algorithm. It is no longer the Coca-Cola company's formula. Used to be the most valuable trade secret, but now I'm pretty sure that as I said, the Google's search algorithm should be deemed the most valuable trade secret. And secondly, as you know, social media companies have not disclosed their algorithm to to the tech people outside of their companies. So their algorithms are only known to a limited group of persons inside their companies, and obviously they have already taken reasonable measures to keep the confidentiality of their algorithms. So social media algorithms in general could be and should be protected as trade secrets. But I also want to address this issue from a corporate strategy perspective. Many social media companies actually have the business strategy to protect their algorithms as trade secrets as well. So I want to compare trade secret with copyright and patents in order to present why it is a corporate strategy. So if we, for example, if we take a look at copyright path and patent path to protect algorithm, then the story will be different. First of all, both areas of law require disclosure in the first place. Normally, we publish works, right? So once works are published and they will be circulated in the market. So it's normally, I said, although there are works that are not published, but normally it is the works that are published that will gain the market share, right? Okay, so it's the normal practice to publish the works in order to have their works protected by copyright law. And at the same time, if you want to have patent protected, right? So the quid pro quo is to apply for patent file for patent protection, and then an applicant has to disclose technical elements contained in an invention. So disclosure is also an essential element of the patent application. So since both areas of law need or even require disclosure, then it is not desirable for social media companies. And both areas of law also have limited term of protection. Okay, copyright law protection normally lasts for life of the author plus 70 years or 50 years in certain countries, right? Okay, and patent term lasts for 20 years, counting from the date of application. But so this might not be desirable for social media companies because many of them, I'm pretty sure, that want to have their algorithm protected, as intellectual property as long as it's possible. So trade secret has this kind of advantage. Once reasonable measures are taken, then algorithm can be legally protected, literally forever. Okay. So that's another reason why, as I mentioned earlier, the law, especially trade secret law, promote this kind of black box society idea, and social media companies are not legally obligated to disclose their algorithms. But this has caused a range of tremendous social problems. So first of all, you can see that such practice, or we can call it algorithmic secrecy, has caused a wide range of harms to individual interest. I think the collection of personal data through algorithms is a prime example. Social media companies have been collecting personal data, right, such as our preferences, our whereabouts, our secret information, right, other kinds of secret information, and they may use such data without our consent, or even sell such data sets to a third party without our consent. For example, the Facebook Cambridge Analytica scandal has proven that data leakage could cause serious harm to our individual interests in personal data. Okay. And Professor Samuelson has already talked about a wide range of harm that has already caught to the public interest. So, for example, we need to deal with democracy. Okay, so how we can maintain a proper system fostering a vibrant culture of free speech. And it seems that the recommendation algorithm, the content moderation algorithm have caused harm to free speech. And I'm pretty sure that Professor Yu will talk about this issue as well. And public health is another primary concern. And the COVID-19 pandemic has proven that the wide dissemination of fake news could cause harm to the protection of public health. I'll talk more about this a little bit later. So how can we deal with such serious problems? As I told you earlier, I'm going to propose a new legal right called the right to know algorithms as a new way of dealing with such problems. So first of all, let me talk a bit about the nature and scope of the right to know. So the right to know essentially is a legal right designed for people to participate in an informed way in decisions that affect them, while also holding governments and others accountable. So first of all, you can see that the international human rights system, to a certain extent, have recognized such right. For example, Article 19 of the Universal Declaration of Human Rights says that everyone has the right to seek, receive, and impart information. And national laws, particularly through various kinds of Freedom of Information Acts, have recognized the right to know. For example, in the US, the Freedom of Information Act has already recognized this right. When President Johnson signed the Freedom of Information Act, he declared that the United States is an open society in which the people's right to know is cherished and guarded. So this right gives any person the legal right to request access to records of the executive branch of the US government. So the ethos of this right is to encourage the government to virtually disclose any record possessed by the government, provided that there will be, for example, no conflict with other interests such as national security. Okay, so this is the an overview of the right to know. So here I provide three justifications for protecting the right to know. First of all, we need to protect and promote democratic governance. And also we need to protect and promote public safety, and it also protects and promote cultural participation. So let me talk the justifications one by one and walk you through these justifications. With respect to democratic governance, there are two kinds of theories of policy arguments that have been put forward. First of all, scholars have argued that in order to protect citizens as watchdogs of a government agency, we need to protect their right to know so that they have the legal right to serve as a check on governmental power. So the government cannot, hide their decisions or other kinds of information in black box manner, and citizens will have the access to know, much of the information. So this will gives the citizen the power, the legal power to serve as the check on governmental exercise of political power. And at the same time, scholars have also argued that if we want to run a proper democracy, we also need to have a well-informed citizenry in order to disseminate information to citizens as much as possible, so that they will be informed of the developments of our society. And so this is kind of self-development for citizens to make well-informed decisions. So this is the first justification. The second justification is intended to promote public safety. There are two elements, primarily two elements. There are other elements, but I want to focus on two crucial elements. One is about environmental protection. So, for example, in the United States, there is a law called the Emergency Planning and the Community Right to Know Act. This law requires industry to report on the storage, use, and releases of hazardous chemical substances to the government. So it's a way of informing the government and subsequently citizens of any potential harm to, especially chemical harm posed to environmental protection. And secondly, you can see that public health is also a very important part of public safety, right? So I wish to use the COVID-19 pandemic as an example to illustrate this. During this ongoing pandemic, we all have learned that access to crucial information about the prevention of the spread of coronavirus and also information about how to prevent from being infected are very important to protect our health, and more so to prevent people from getting infected and dying. Proper access to information like that is crucial, and people should have the right to know such information. And cultural participation is also very important. We need to promote access to various kind of cultural resources. It's very crucial element of human flourishing. So equal protection of, for example, social statuses such as race, gender is essential to cultural participation, and the right to know promotes cultural participation. So let's move on to talk about why we need to recognize and then protect the legal right to know algorithms. So similarly, I want to base this new legal right on the 3 justifications as well, namely democratic governance, public safety, and cultural participation. Okay, so first of all, with respect to democratic governance, I think social media algorithms in particular have a very close bearing on the promotion of this democratic institution. And I wish to use recommendation algorithm example to illustrate this point. Oftentimes, social media companies, wish to increase their user engagement and, in particular, maximize their advertisement profits. So they have been using recommendation algorithm to, for example, to present information about the results of our internet searches, and also, for example, disseminate information such as news, advertisements to users. So through the operation of such algorithms, they normally could, or we could even say that they frequently curtail the free exchange of ideas by promoting or relegating content in an ad hoc, automatic, and opaque ways. So we don't really know how they come up with, for example, search results for us. We don't really know how they, the way in which they present news or advertisements to us. So the opacity of recommendation algorithm could cause threat to the first element of a democratic government, citizens serving as watchdogs of a government agency, because citizens might not be able to have the information that they want to get through social media platforms. As I mentioned earlier, it is the algorithm that disseminate information instead of giving citizens the power to decide what they wish to see or what they wish to watch. It's normally algorithm would disseminate, right? Okay. So to a certain extent, I said to a certain extent, it will affect citizens' capacity serving as watchdogs in this regard. And of course, if citizens are not capable of deciding what they wish to see or what they wish to watch to a certain extent, then it will also cause harm to this idea of fostering a well-informed citizenry. So let me move on to the second justification about public security. So public security, as I mentioned earlier, is another essential public interest that the right to know is designed to promote. So in this area, I wish to use content moderation algorithm example to illustrate the problem and the high stake that is involved in the application of an algorithm. So a content moderation algorithm largely could moderate information moderate the dissemination of information such as fake news. And these algorithms have the power of significantly amplify the impact of fake news on social media platforms. So first of all, once fake news is disseminated on social media platforms and it is not stopped, then it will be quickly and widely disseminated across various kinds of social media platforms. So the impact will be widespread in the first place. At the same time, the amplification of fake news through algorithms could cause the problems of echo chambers, so that fake news, while fake news is widely being disseminated, right, at the same time, it will particularly be disseminated through like-minded people. And then once people receive information like that, they will just stay in their own social circle, and they will not be able to reach out to the peers or other people, many users on social media platforms. So this kind of like-mindedness will be egregious in the discussion of many social and political issues. I think the COVID-19 pandemic, again, has proven the serious problems that fake news has caused. We have seen a whole range of fake news regarding coronavirus. And so the problem have been so serious that the World Health Organization actually declared that, well, the COVID-19 pandemic is actually a global public health crisis. It's actually also an infodemic. So that's why we also need to deal with social media algorithms through this perspective. We need to protect public safety. And cultural participation, as I mentioned earlier, is the second element, the third justification. And I think, I want to be very brief because it seemed that I'm kind of running out of time. So you can see that algorithms have also caused social problems such as racial and gender discrimination, right? So these stories have been headlined by many media. I think this is quite clear cut. So what can we do then? How can we protect this new legal right if we ought to recognize it? So I have two proposals. First of all, we can set up legal initiatives for disclosing algorithms. I think Professor Samuelson has already talked quite a lot about that. And at the same time, courts can be called upon to make decisions regarding whether algorithm could be disclosed or not. So with respect to legislation, some countries, as I mentioned, have already enacted laws designed to regulate algorithms. You can see China has adopted regulatory decision, and France has enacted the so-called manipulation of information law in order to deal with how algorithm could disseminate fake news. And legislators in the United States also have enacted laws. Proposed laws to deal with such problems. So one of the primary challenges for legislating law is about how we can require social media companies to disclose their algorithms. So this is a major concern. I'll talk a little bit more about this later on. Okay, and also there's a problem or its consideration about how they can make their algorithm explainable. But by and large, I think we need to be informed, users at least need to be informed of how algorithms function, at least. Not total disclosure of all algorithms, but users should be informed of the crucial elements, how these algorithms could function, so that they can have, for example, an option to decide how to, for example, stay away from certain kinds of algorithm, the opt-out option. And I think, as I mentioned earlier, courts could also be called upon to make decisions. If we recognize this right, then they can decide by relying on this new legal right to decide whether social media companies should disclose their algorithms in certain specific cases. And in European Union, courts actually have relied on the so-called the right to explanation under the GDPR to make such decisions. So they have provided lessons for us to decide. I'm running out of time, I think. So let me be very quick. There are also, I think, legal challenges against the protection of the right to know algorithm. So I want to quickly talk about the so-called Fifth Amendment challenge, because Christopher Yu is going to talk about the First Amendment challenge. So first, according to the Fifth Amendment, governments cannot take private properties for public use without just compensation. So this could be a legal ground to challenge the disclosure requirements, because algorithms could be protected. Trade secrets, right? Trade secrets to a large extent could be deemed as private property. It's a controversial issue, but could be, as I said. So it could be a legal challenge like that. And so if we had a legal challenge like that, I think one of the crucial issue would be whether, an algorithm has been taken as a property by the government. But I think it should, by and large, not be seen as a taking of property in the first place, because, as I mentioned earlier, we are not requiring, the complete disclosure. We're, at the same time, we could ask them to provide explanations about, for example, the functioning of their algorithm, right? So it could not, potentially, it could not be seen as a taking of property in the first place. So there are also technical challenges, I think, and Professor Samuelson has already talked about this. I just want to quickly mention that in addition to the technical difficulties in disclosing source codes, we also have the difficulty in disclosing, for example, algorithms through the involvement of data, because algorithm cannot be functioning properly without the involvement of data sets. So the explainability of algorithm also has to rely on the disclosure or explaining data. So that's another layer of difficulty. But I think it's also an opportunity, right? Since there could be technical challenges for disclosure, or even for people to understand such disclosure, and it could be an opportunity for social media companies to keep the confidentiality of their algorithm to a certain extent if there are disclosure requirements. But by and large, if we require them to disclose, and we also need to deal with these difficulties, but as Professor Samuelson pointed out, these are all ongoing discussions. So I also look forward to discussing with the audience and other panelists how we can deal with such problems. So thank you so much. I look forward to other talks and discussions.
Thank you very much, Professor Sun. That really did follow on Professor Samuelson's comments perfectly, and of course extends your right to technology book in a new direction still with the right to know algorithms, particularly in the social media context. Just a reminder to the audience, we'll have plenty of time to talk about your questions The Q&A is already open, so you can start typing questions, and I'll read some of those questions to our panelists after we hear from each of them. So we have two remaining panelists, and that will be Christopher Yu, and then after him will be Woodrow Hartzog. So Professor Yu.
Well, thank you very much, Professor Chander. It's a pleasure to be here, and thank you to University of Hong Kong and the other organizers for making all this possible. It is an honor to share a panel with so many friends and distinguished colleagues, and I'm happy to have what I think what my presentation is going to be largely complementary to what has been going on before, which is, how Professor Sun has mentioned, he has reserved the issues around the First Amendment. Well, that's where I'm going to go. And in fact, the issues that Professor Samuelson spotlights in the Gonzalez case and in the Tomah cases are really about the underlying cause of action, the statute, whether liability actually exists. I'm going to talk about cases where the construction of the statute really isn't ambiguous at all. It's whether there are constitutional or civil liberties limits on what those enactments may be. And so in some ways, I think we're moving to another question that regardless of how the statutory issues that Professor Samuelson raised are construed, the constitutional issues will remain. So to give a brief overview of how I'm going to talk with my talk, first, I'm going to set the stage based around two decisions in cases called the net choice cases, one out of Florida, one out of Texas, which are pretty much most of us regard on a collision course for a decision in the Supreme Court sometime next year. And then we'll look at the Supreme Court's jurisprudence on respect to false claims, with respect to balancing political speech. I actually, in light of Professor Samuelson's presentation, added another slide on Supreme Court decisions on disclosure. And we'll talk about the theory underlying these decisions, what indications we have from actual opinions, and then my assessment of what's going on here. Of course, the assessment is worth every penny all of you paid for it. Rely on it at your own hazard. So as we all say, I think Yogi Berra said, predictions are hard, especially about the future. And all of us have spent a lot of time trying to explain how certain predictions we made about how law is going to turn out in a certain way didn't come out. I will focus primarily on US law on this discussion, although I will, particularly on the last slide, have some discussion of how it implies, what these different things imply, perhaps outside the context of the US. So setting the stage, going first to the net choice cases. Both the states of Florida and Texas enacted statutes that prohibited social media from censoring based on viewpoint. And they really are concerned about deplatforming and what's happening with that. Yes, both statutes, as Professor Samuelson notes, include disclosure requirements, but the part that's obviously going to raise even more constitutional issues is the direct regulation of speech, prohibiting social media from taking certain actions. That is, having to carry certain people and not having the latitude to refuse to carry them. And both of these cases ended up with very different outcomes. They both were held unconstitutional by the U.S. District Court, which is the trial court that determined them. But on appeal, they went in opposite directions. The Florida law was, they followed the district court's decision and held that the Florida law was unconstitutional in May of 2022. The Texas law was actually held constitutional by the Fifth Circuit in September of 2022. And so now, even though they're technically different statutes, they're very, very similar, and the issues raised are almost identical. And in fact, both cert petitions have been sought in both cases, and they've been distributed to the court, and the conference at which the court is first going to evaluate whether to grant these cases is January 20th. For those of us who follow the court, this, under normal circumstances, is past the deadline for having it heard this term. The way the court generally works is they continue to hear arguments through May, then they decide through April, I think, and then they have all the decisions out by the end of June. And there's a deadline, there's a briefing schedule that requires a certain amount of time. And that granting it on January 20th is usually not enough time to get it heard this term. Under extraordinary cases, they can, even under the decisions, grants made yesterday, or I mean, just I guess over the weekend, last Friday, those, even to get those in, require an abbreviated briefing schedule, and this will require a really aggressive one if they're going to get one in this year. Most of us suspect, who just counting the number of days, I don't think that it's likely to be heard this year, but it's not inconceivable. So we have a conflict here between two very, very different outcomes, which require which limit social media's ability to determine what they're going to carry and what they're not. And we have a lovely circuit split burgeoning here. So how are we going to understand this? So what's interesting is the Supreme Court doctrine generally takes a pretty dim view of direct restrictions of speech, and in particular political speech. In the famous Justice Brandeis' famous concurrence in Whitney versus California, really the remedy to be applied to false speech or bad speech is more speech, not enforced silence, or in where this is going with compelled speech. So basically, the remedy for a problem in the speech market is more speech, and that doesn't require anyone to be restricted. That was a concurrence out of Whitney. We see in the landmark case of New York Times versus Sullivan from 1964, a decision that Thomas Emerson said was the famous University of Chicago First Amendment scholar and later Yale scholar, said it was an occasion for dancing in the streets. Well, first, there were two questions in Sullivan. One is, many people thought that the First Amendment only applied to what we call prior restraints, that is, ex ante restrictions on speech. Sullivan made clear that ex post tort liability can chill speech just as much as ex ante restrictions and prior restraints, and that in fact we have to analyze after the fact liability as a potential First Amendment issue. And second, Sullivan laid out a standard for defamation called the actual malice standard, that the speaker had to know it was false, the statement was false, when the speaker made the utterance, if it is going to, when this utterance is about a public figure, if there's going to be defamation liability. And the reason for it is that basically political debate needs some breathing room. And in fact, there's going to be some room where not everything you say in a political debate may be 100% accurate, but without that kind of breathing room, you can't really have political discourse in an important way. And so what we see is the actual malice standard is intended to give you a little room where you can even actually make some false statements, so long as they're not knowingly false at the time you made them, and avoid liability. And we see in a series of subsequent decisions based on false speech, and this is what we think about as fake news, some decisions that have essentially reinforced this idea. There's a 1982 decision called Brown versus Hartzog, where a political candidate promised not to take all of his salary if he were elected. And it turns out that is illegal under Kentucky law. You're not allowed to give someone economic consideration in order to get their vote, and reducing the burden on the public fisc could arguably be that. And so he immediately retracted the statement, long before the election. And basically, they took a pragmatic point of view and they said, yes, it's false and it violates the statute, but we're not going to mandate a new election just because of that. In fact, there was a disclaimer, and in fact, there was enough time to correct the idea of what's going on. In United States versus Alvarez, a person started bragging that they were a military veteran and said they'd received the Congressional Medal of Honor. All that was false. And there's actually a criminal statute at the time that made that illegal. And basically, even though it was clearly a false claim, it was incorrect, the Supreme Court said, basically, this is a lot of puffery. There's not a whole lot riding on this. And even though we want to honor our veterans, this is not appropriate to put a person in jail for these kinds of clearly stating false information. So this is, again, that kind of breathing room that we need, and a fairly robust vision of how society operates, very much in the spirit of the Whitney concurrence of we want more speech in the market, not trying to directly regulate the speech by trying to correct for problems by restricting what people have to say or forcing people to say things. Now, forcing people to say things is really the focus of this slide. The first one was more about restrictions. There's a series of Supreme Court decisions on government attempts to balance speech markets. So probably the opinion that most people look at is a case called Miami Herald versus Tornillo, where the Florida law required that any newspaper that endorsed a political candidate had to give a right of reply to the candidate's opponent to allow them to get the chance to speak. And the court said that was unconstitutional. You can't take a newspaper and make it print something that's against its editorial vision. And they said that in fact, editors, that's what they're for. And in fact, that's how they speak. There is an exception for broadcasting, mostly radio, but now also television broadcasting, based on the idea that there was a physical scarcity of the spectrum. This rationale has been subject to a devastating critique started by Ronald Coase and actually accepted by the Supreme Court in Turner. In fact, it's not simply that the spectrum is scarce, in fact, everything is scarce. And this rationale fails to distinguish broadcasting from any other medium. And that, in fact, what you see is in the Turner cases, a pretty strong endorsement of the critiques and saying that this is invalid, scarcity doctrine is invalid. But in addition, what you see is a series of decisions where the court was asked to extend the scarcity doctrine to a series of other communications media, including telephone, cable television, and internet. The Supreme Court has consistently refused to extend it to anything else, and has even indicated some reluctance with respect to broadcasting itself and some willingness to overturn it with respect to that. So what we see here is this notion of engineering speech to balance things out or to make people carry things to make sure that things are balanced is generally perceived as violating the First Amendment, subject to this one narrow restriction that is not proving to be very generative. There's also, you get the same rationale coming out of the campaign finance decisions. We saw in previous decisions going back to 1976 in Buckley versus Vallejo, where we saw a more permissive attitude towards campaign finance laws. More recently, we've seen a series of decisions that have said basically that holding campaign finance restrictions unconstitutional. Citizens United, probably really the first of these series, overturned restrictions on independent political ads, saying that corporate actors should be able to spend and back up their speech without limit, and the government can't put restrictions on that. The Arizona passed a regime that allocated public funds to candidates who attracted fewer donations. And in fact, that was declared unconstitutional by the Supreme Court in 2011. And in the McCutcheon case, the court overturned contribution limits to campaigns. And so what you see here is a series of decisions very counter to the idea that the government can come in and think about what a good market for the speech should look like, and then put restrictions on to sort of correct market failures or to engineer the proper speech market. On discourse, what you see here is some interesting decisions really saying the state cannot require disclosure of authors, the source of who authored particular political pamphlets. You could think about this as a broad prohibition of disclosure. And you see in the rationale that the state of California and the state of Ohio actually both asserted that preventing fraud in elections and informing the public were justifications that were sufficient to survive First Amendment scrutiny. In both cases, the court rejected those rationales. And so what you see again here is something trending towards an idea against these sorts of disclosure regimes. There are a couple of caveats. There is parts of the reasoning that suggests that it may not be as broad as that. First, some of the aspects of it really pinioned on this idea of political speech. They were talking about fear of retaliation. They were also talking about how other safeguards exist within the regime that penalize fraudulent political speech, that made the publication of pamphlet authors overbroad and not well tailored to the actual problem. So it's not entirely clear from these decisions what would actually happen, and we end up having a fairly, I think we'd have to have a very interesting discussion, especially if these come up in the net choice cases. And then in addition, they have other decisions that, we also have Bonta, which says you can't disclose donors. But labeling is interesting. There is a case called Meese versus Keene out of 1987, which required that movies be listed as propaganda if they raise certain themes. And the Supreme Court has said that that wasn't necessarily problematic. So labeling generally gets a freer pass. The exact scope of the limits on disclosure have to be determined on a case-by-case basis. Keene has some other things, and you see this, for example, in like film rating systems and the like, and you see different ones of them coming out in different ways, depending on the tailoring. So and that's it for Supreme Court in terms of what the cases say. Let's start to talk about the rationale. Why does U.S. law come out this way? And I would say that even though we talk about things like the marketplace of ideas, which are really about consequentialism and about really what's good for society, I think the unifying theme in the Supreme Court's decisions is to promote a strong civil libertarian perspective that focuses on the liberty of the speakers and not really on the impact on society, and really limits and distrusts the ability of the state to engineer a proper speech market in the vision along the lines it sees best. I've shown you some cases. There are a bunch of others where basically the Supreme Court has protected extremely abhorrent speech and extremely low social value speech, mostly because it appears that they have this conception that really it's a speaker-based civil libertarian conception of what the First Amendment is. And to understand where, the justifications for that, part of this is based in liberal theory, why we have elections, why we believe in democratic forms in the US is because really the state is created by people, and the state exists to, fulfill their will and in fact to achieve their goals. And put a different way, people are the subjects that create the state. They should not be the objects on which the state operates. And that in fact, you see this reflected in our social contract theory going back to John Locke. And you see this in the Essays on Liberty by Isaiah Berlin. And you see a very long legacy of this idea of the proper relationship between the government and the individuals. And it puts the individuals prior to the government, and the government is intended to fulfill their desire not to turn around and change what their desires, because their desires seem to be improper. And there's also a pragmatic component to this, which is there's a belief that even though private abuse does exist, correction by the state would be worse, the cure would be worse than the disease. And you see a long legacy of this in Milton's Areopagitica, which critiqued the Guild attempt to use licensing to prevent publishing of books without state approval. You see Max Weber's concern that the state has the exclusive monopoly on the legalized use of force, which makes them more dangerous. And you see a series of Supreme Court decisions, I list a couple of them here, that really say private abuse exists, but government correction is the antithesis of the First Amendment. Part of it's textual. It says Congress shall not abridge the freedom of speech. But part of it is sort of a belief that, in fact, that the danger of enabling the state to step in and to engineer a proper speech market raises serious risks of giving them too large a role in politics and controlling discourse. In fact, there is another line here, which is they're saying it's not just speech, but editorial discretion over whose speech to host is also protected in the First Amendment. A long series of decisions coming from newspapers, cable television, broadcast television, and Hurley is a parade, the St. Patrick's Day parade in Boston, very well known. And that in fact, they say that this is an important First Amendment right that should be realized. There is an exception when the discretion you exercise is not attributed to the platform. We have a couple cases, Pruneyard and Rumsfeld versus Fair. I would say that in this case, to say that people aren't attributing the editorial decisions of who to carry and not to carry to the platforms seems pretty clear that that rationale wouldn't take them outside this doctrine, that people are holding the platforms responsible for the decisions that they're making, and that in fact, that seems to take it fairly easily outside the exception. And the real embodiment of this principle is the state action doctrine, which is that the First Amendment limits only the government. It doesn't actually limit private actors. The whole notion of what we call private censorship is a contradiction in terms. And there have been a number of calls by scholars and others to abandon the state action doctrine, but to date, the Supreme Court has shown no indication or no willingness, inclination to do such a thing. I only I show here the two most recent cases, Haochen versus Manhattan Community Television and Biden versus Knight First Amendment Institute are both examples of where the court has really adhered to that. And so that shows no sign of weakening. There was a time in the 1970s where it seemed like there was a serious call, but those days, those calls in certainly the Supreme Court have gone well by the wayside. So that is the rationale of why things are where they are. Let's see if we can prognosticate the future by reading the signs. So what we see is, as noted by Professor Samuelson, there have been some calls to deviate from existing law. Justice Thomas has called for greater restrictions on social media, particularly in the construction of Section 230 and his concurrence in Biden versus Knight First Amendment Institute. Notably, by the way, he is concurring in that when they remanded that case, granted and remanded a case, because he did that implicitly says the state action doctrine they dismissed it actually on mootness grounds as well. But the decision below is on state action, and you see here an endorsement of that idea. In another decision called Barishaw versus Lawson, Justices Gorsuch and Thomas have called for rethinking and possibly softening New York Times versus Sullivan. And again, that's one justice on the first issue and two justices on the second issue. It's a question of, that's all well and good, but until you get to 5, nothing actually changes. And so there is one other indication from the Supreme Court's docket that may provide some clues about how the Netchoy cases are going to come out and how law doctrine is going to develop. When the Fifth Circuit case was decided, the district court, as I said earlier, declared the Texas law to be unconstitutional. The state of Texas filed an appeal with the Fifth Circuit Court of Appeals. And then at the same time, they asked the Fifth Circuit to grant, if they would grant a stay of the mandate of the district court pending appeal. And one of the issues in whether to grant such a stay is likelihood of success on the merits. And the Fifth Circuit granted the stay because they actually ended up holding it was constitutional, and they thought that in fact the appealing party was going to prevail. This stay was then appealed to the Supreme Court, which faced the same legal standard and asked, should we dissolve the stay of the mandate that the Fifth Circuit issued? And the Supreme Court voted 5-4 to yes, to vacate the stay issued by the Court of Appeals. And again, because one of the requirements is likelihood of success in the merits, this is signaling by the Supreme Court, or many of us who try to read the tea leaves, think that, in fact, the Fifth Circuit's going to get reversed when these cases get consolidated and eventually granted and heard by the Supreme Court. And what's interesting, it's a 5-4 vote, but 3 of the justices, Alito, Thomas, and Gorsuch, joined in an opinion authored by Alito, really disputing the merits of the decision. Justice Kagan doesn't like deciding things on the motions docket, doesn't like making substantive decisions. So she voted against or dissented without opinion, and many people believe that's for procedural reasons, not for substantive reasons, and that leads to a wide-scale suspicion that there's in fact still a 6-3 majority for adhering to current law, although again, if the grant occurs, we will find out soon. Okay, so in terms of some assessment of what's going on here, so what we see here is that the doctrine under the Supreme Court really prohibits interference with editorial discretion, and that includes decisions about what kind of content to host. In that sense, we see here a pretty strong First Amendment protection that's likely to apply to direct restrictions that either prohibit people from exercising, from restricting people from putting on certain types of speech, or requiring that they keep carrying certain types of speech. And that goes into compelled speech doctrine also in the US law. And that, in fact, this is motivated by a speaker-based perspective that really prioritizes the individual speaker's liberty over the social impact of the speech, which has generally not been sufficient in most of these cases to overcome it. As I just said in the last slide, the stay decision in the Texas case suggests that the law is unlikely to change soon. This does have some implications that if the statutory decisions that Professor Samuelson pointed us at are decided in a particular way in favor towards liability, and we see there a question of first, is it a prima facie case under the Anti-Terrorism Act, under the aiding and abetting, is the conduct sufficient to constitute aiding and abetting? Second, even before you get to the constitutional issues, even if prima facie liability exists, does Section 230 create a defense? And then we have here as a potential First Amendment issue is that if you're penalizing someone or limiting for exercising editorial discretion or limiting their ability to do that, that may run into First Amendment arguments that may come up in the type that are raised in the Gonzalez case. And that, in fact, what's quite interesting to me is people who would like to ban any form of algorithm or targeting are, in fact, presuming a platonic ideal that of an idealized speech market that in my opinion doesn't really exist. Even first come first served is a algorithm that has predictable biases, and there's a literature that explores that. And that's a really interesting fact that no matter what you're doing, you are exercising some form of editorial discretion. And the idea that there is some world out there where you don't exercise any in a content-based world is not entirely clear. And then lastly, just to echo the points that Professor Samuelson meant, that disclosure is out there as a separate issue. It raises fewer problems than direct restriction, obviously, but it's not entirely clear in the bigger picture exactly how that'll play out, because the cases here are much more nuanced, and it will require a lot more evaluation for deciding whether the types of disclosure-based solutions reflected in Texas and Florida, in which Professor Samuelson discussed, will survive constitutional scrutiny. Lastly, as promised, I would say the word I would say about generalizing to other jurisdictions. I will say that, in fact, the speaker libertarian vision does not actually apply to all jurisdictions. First, I think from what little I defer to the many experts on China here, but in fact, my understanding is under the Chinese political system, the party is supreme, and there is no part of the individuals that are prior to the party, in which case that rationale doesn't have as much traction under that approach. But even ones who would actually not just would buy into a liberal perspective and take the deontological considerations seriously, but in fact would balance them against societal considerations, the problems of weighing deontological principles against consequentialist principles is one of the most difficult and fundamental problems facing us in the law. And that, in fact, we actually have to make those decisions all the time, and they're very common. But this does require a very difficult set of metrics that are very vulnerable to abuse. And that, in fact, you see in the US Supreme Court jurisprudence a real hostility towards balancing in First Amendment jurisprudence for that reason. And that, in fact, other jurisdictions which like to go down this road will have to confront some very difficult questions. All right. Well, thank you very much. It's been a pleasure being here, and I look forward to Professor Veach's presentation and the question and answers.
Great. Thank you very much, Professor Yu. That was a wonderful and really masterful account of the First Amendment questions in these cases. Now, our final speaker for this panel is Professor Woody Hartzog. Woody.
Thank you so much, Professor Chander. I really appreciate it. Thanks to everyone at HKU for having me here today. I really appreciate it. It's great to see some longtime friends and be on a panel with such amazing scholars. So I wanted to talk to you today. I really appreciate the ability to go last today because, at least on this panel, because my presentation is going to be about a way to possibly think differently about regulating social media algorithms than some of the ways in which we have predominantly been thinking about regulating algorithms, which includes perhaps a way to get around some of the limitations of a transparency or disclosure regime, as well as some of the being compliant with a lot of the free expression guarantees that we have in the United States and in other countries. So the title of my presentation is The Duty of Loyalty for Social Media Algorithms. And I'm not going to spend a lot of time focusing on the harms because they've actually been really well covered by Professor Sun, and others. But I do really quickly want to say that social media algorithms do raise a host of a lot of different possible harms, including privacy harms, because algorithms are often reliant upon incredible amounts of data, which creates a lot of incentive for social media companies to collect a lot of that data, to leverage a lot of that data, to encourage us to keep clicking and exposing ourselves. There's been a lot of discussion around the concept of mental health and social media algorithms. I think that there's been a fair amount of discussion on that already. I just wanted to note that this is, in fact, one of the significant adverse consequences that scholars are exploring right now regarding how social media algorithms are meant to make us think and feel and see and do certain things. And finally, of course, a lot of our discussion today has been around self-governance and community cohesion and social media algorithms and things like fake news and polarization and intentional outrage and engagement. All can be negative outcomes from the wrong kind of social media algorithmic amplification or editorial discretion. And so one of the things that I want to propose today is that lawmakers, we spend a lot of time talking about these harms, but I think that maybe lawmakers are only seeing half of the equation. And the other half, I think, is the relative benefits that organizational actors and individuals might see from social media algorithms. And I know that a lot of those are intuitive, but what I'm proposing is that lawmakers have failed to compare them with the harms, particularly the relative benefits and distribution of risks and harms. And what I mean by that is exploiting human attention, data, and labor is incredibly profitable for companies. It has helped make some of the most profitable companies that have ever existed. And in many circumstances, people actually get relatively meager benefits from social media algorithms, algorithmic amplification, depending upon the context. In other words, I think that there is an imbalance between the distribution of benefits and risk. And to put a different way, people trust social media companies with an incredible amount of personal information, with their mediated experiences, with what they see. And there is a remarkable opportunity for these organizations to engage in disloyal self-dealing with the design of these algorithms. And so I really want to make 3 points. One, the law does very little to limit companies' self-dealing with people's data and online experiences. Lawmakers should impose, in my opinion, a duty of loyalty on social media companies regarding their data collection and design of algorithms and user interfaces, and I'll explain what that might look like in a minute. And one of the reasons why I am in favor of a duty of loyalty is that it would help mitigate many of the weaknesses inherent in the current regulation of social media algorithms. So what do I mean by that? Well, right now, and I talk about this in my privacy law class as well, we've really got 3 major approaches to regulating data and algorithms. The first one, which we heard a lot about from Professor Samuelson and Professor Sun, is transparency or mandated disclosure. I like to call this the do not lie principle. Just do what you're going to do, just don't lie about it, tell us, be very transparent. As has already been well covered by Professor Samuelson and Professor Sun, algorithmic transparency has its upsides, but it also has its limits. It doesn't really protect against opportunism or disloyal self-dealing. Why is that? Well, because it's easy to bury technical truth in all sorts of mandated disclosures. Where do you put them? Where would you put something that you had to disclose, but you weren't allowed to? You would put it in the terms of use, because very few people read the terms of use. It can be confusing. It can be something that is easy for people to gloss over. And so technical compliance that can basically still allow for companies to engage in self-dealing in ways that are adversarial to us. The second major sort of approach that we have in regulating data and algorithms is do not harm. In other words, you can do whatever you do as long as you don't hurt people with it. But there too, we run into some real problems, because a lot of the extreme adverse effects from digital technology manifests, they're really often felt in dispersed ways, in incremental ways. They're maybe not felt individually. They can also be really difficult to quantify. They could be small incursions that never really register as potential legal violations, but in the aggregate can be an incredible drag, again, on our mental health, on our well-being, on our democracy, on our communities, and on our seclusion and freedom. And so the final rule that we have in data and algorithmic regulation is really follow the FIPS, the Fair Information Practices. Now, the fair information practices are a staple in data protection law, but we have leveraged them in a lot of algorithmic regulation discourse, things like algorithmic transparency. Professor Sun was talking about the right to explanation. But a lot of the problem of the FIPS mentality is that it distills down to the concept of giving people control over the algorithms, control over what data is collected, control over what they see. And that sounds enticing. It sounds great. Who wouldn't want more control over things? This is autonomy enhancing and something that's very good. The problem is that control is manifested in digital environments by this, a nice little on and off button. Now, this on and off button works pretty great in isolation, right? Do you want to see an algorithmically sorted feed, or do you want to just see it chronologically? Although, of course, again, to recognize Professor Yu's comment, even that is a choice, chronological. But there are more sophisticated ways of algorithmic sorting, or perhaps more simplistic ways. And so we say yes, we say on, off, right? We turn it on and off. But then, of course, it's never just that simple, right? It's buried in a significantly larger number of choices that all of us have to then sort of grapple with, right? And we do this every single time we pick up our phones. And so we fiddle with all these things, and we spend a few minutes, we say, okay, I have sorted the social media algorithms. I have control over what I see and what is collected about me and how my information is used. And you're fine. And then you take a deep breath and you say, oh dear, I've got a lot of work to do. The problem with thinking about control as the pole star of algorithmic regulation is that we get so much control that we choke on it and it overwhelms us. But I want to suggest today that there is, in fact, another way that we might go about things. And that's regulating the relationship of trust between people and social media companies. Now, a lot of relationships do get regulated, relationships of trust, trustee and guardian relationships, principal-agent relationships, there's corporate fiduciary obligations. But I want to propose that modern information relationships are completely distinct from traditional arm's length relationships where people are presumed to have relatively equal bargaining power under traditional contract law principles. And here's why. There is nothing that we have ever seen in the history of mankind, and I realize that's a very large claim, that approaches the kind of relationship that people have with social media companies. They are ongoing. If social media companies are to have their way, they will last literally forever and through death. And if you want to look at all the options for what happens after you die for your social media account, most of these companies now have browsing habits for you, right? That you can go choose what happens post-mortem because they're anticipating you're going to be with them for the rest of your life. They are frequent. It is not the kind of thing where we walk into the store once every couple of weeks or whenever we need something. People pick up their phones hundreds of times a day and they check phones and apps multiple times a minute. It's the most frequent interaction we have with any entity, I think, probably in our lives. They are interactive. It's not as though we're just watching and consuming things, though of course that's part of it, but we are clicking, we are sharing, we are exposing ourselves every single time we engage with this trusted entity, and we are trusting them with what we see and with our personal information, and they are constructed. In other words, we can only click on the things that they give us. It is entirely one-sided. We don't get to choose what the interfaces necessarily look like. Rather, it is entirely something that is mediated for us. And then finally, they are responsive. They change with us. Not only are they personalized individually to us, and this is where social media algorithms come in, but they change as our relationship with the company deepens, right? That they in fact change with us. And so given this unique, potent combination of factors, the social media user relationship is one of the most uniquely vulnerable, I think, in our lives. And when you have an incredible power imbalance like exists with those between users and social media, traditionally the way that the law responds to that is it imposes obligations to keep the more powerful party from engaging in disloyal self-dealing. And the way that they do that is through a duty of loyalty. And so what I'm proposing here is a duty of loyalty that data collectors and social media companies must refrain from data processing and technological design that conflicts with the best interests of the trusting party with respect to their personal information and mediated experiences. This is not just a pipe dream. This is not something that I dreamed of last week. In fact, a duty of loyalty is making its way into lots of different bills. It is already part of the Digital Governance Act within the EU. It has been proposed both at the federal and state level in multiple bills in the United States. And I've highlighted just a few examples of language where a duty of loyalty has been proposed for technological design and data collection. And it actually has already made it into state law in California as part of California's age-appropriate design code, which has specific language about prioritizing the best interests of children when it comes to the design of information technologies. And so this is basically what a duty of loyalty looks like. There are two different kinds of loyalty. One is an obedience standard, and the other one is a best interest standard. And California embodies a best interest standard here. So what would this look like actually in practice? Well, in a lot of research engaged in with Neil Richards, who's a professor of law at Washington University School of Law, we've developed an approach to data loyalty that we call the loyalty two-step. And the first step is a general rule prohibiting data processing or the design of technologies, including social media algorithms, that conflict with the best interests of trusting parties with respect to their data and mediated experiences. Now, that's very vague, and a lot of people feel very uncomfortable about just having a general prohibition that would on disloyal self-dealing. And so what we propose is, in addition to this catch-all, this umbrella obligation, having more specific subsidiary duties in areas where the incentive for conflicted self-dealing is the greatest. And so very quickly, I'll just go through the five that Professor Richards and I have proposed. Loyal collection. This would be specific data minimization rules like the kind that we've seen in the EU's GDPR. Loyal personalization. For advertising purposes, this could be something like a prohibition on cross-contextual behavioral advertising. For non-advertising purposes, it might be more of an obedience standard, depending on what that would look like. Loyal gatekeeping, this has to do with robust data security standards, but also the sort of privacy safeguards that should have been in place for Facebook and the Cambridge Analytica scandal. Loyal influencing, this has to do with dark patterns and the use of algorithms to wrongfully manipulate people into making choices against their interests. Here we would propose a anti-abuse standard, sort of like what the Consumer Financial Protection Bureau has, in addition to their authority to police unfair and deceptive trade practices. And finally, loyal mediation, the idea that companies should not disloyally pit users against each other in order to juice engagement metrics for financial gain. So in other words, we've seen a lot of discussion around algorithms that amplified those posts that were most likely to incite rage on behalf of the other users. And we consider that a disloyal practice and one that would be prohibited under this kind of regime. Now, what are the benefits of a duty of loyalty? We think that there are many. One of which it avoids the harm conundrum. It can be very difficult to identify when an algorithm actually creates a harm, particularly when that harm is felt at scale. But under a relational protection, when one violates a duty of loyalty, you don't need to prove a harm other than disloyal behavior, because the harm is to the relationship itself, the ability to no longer trust the trusted party. It is less likely to clash with free expression goals and rules to the extent that relationships are voluntarily entered into by social media companies. We see that duties of loyalty and confidentiality predates the United States. They are quite old and established. They're sensitive to the incredible power disparity that people have, compatible with data privacy frameworks. And I think maybe most importantly, capable of rallying public support for new laws, because a lot of talk about regulating social media algorithms can be confusing and difficult to foment democratic support for, but every person knows what it's like to have been betrayed. And that's what this would prohibit, is betrayal within a relationship. And so we think it would be a remarkable way to rally public support for new laws. While we think that a duty of loyalty would only be one piece of the puzzle, we think it could be the piece that makes all the other pieces work. Thank you very much. I appreciate your time and look forward to the Q&A.
Thank you very much, Woody. I really appreciate that. That was a wonderful presentation of the concept of a duty of loyalty applied here to social media algorithms and social media enterprises more generally. I don't know if we have, so Haochen, I'm going to come back to you to tell us whether you believe we have time for some questions.
We could have like 10 to 15 minutes for Q&A.
Okay, sure. Yeah. Let me begin.
We can start the second panel a little bit later, you know.
Okay.
On you.
Yeah, I think we should keep the second panel on track, because I'm on the second panel and it's going to get late, very late for all of our.
Right. Yeah, we'll be brief.
So yeah, perfect. Yeah, but for the folks on the East Coast, it's basically my bedtime already as it stands. So I wanted to come to let me begin with Woody, actually. Woody, you've got this, you briefly mentioned at the end kind of First Amendment concerns, and you thought social media duty of loyalty would be compatible with First Amendment concerns, the kind that Christopher raised. And could you spell that out a little bit? I take it that you think that because they are relations by choice, that a duty of loyalty doesn't, in fact, kind of impose speech obligations or other obligations that interfere with the free exercise of speech by the social media platforms. But I'd be curious how you kind of manage that relationship.
Sure. So I defer a lot to Jack Balkin's work, who wrote an excellent article on the concept of information fiduciaries as a way to better sort of harmonize free speech principles and privacy principles. But the short of it is that it's been long established that, consistent with free expression principles, when one voluntarily enters into a relationship and invites someone to entrust them with a lot of something, right? So in this instance, it would be, please give me your data, please give me your attention, please, allow me to shape a mediated experience for you. As part of that exchange, the law has consistently said, when you're at an incredible power advantage, then there are certain obligations that have to come with that. And fiduciary obligations have been generally consistent with free expression principles for quite some time. And so I think that is the sort of voluntary nature. It's not just the voluntary nature to enter into any relationship, but rather one of the most unique relationships that we've ever seen, that involves companies requesting all of this information and all of this attention and all of this sort of well-being lying in the hands of these companies. And that would, in fact, give rise to voluntarily assumed obligations, given the incredible disparities inherent in those relationships.
And Professor Samuelson, an anonymous attendee asks a question, and I'm going to paraphrase the question a little bit. The person asks whether a merchant might apply different prices to the same, might offer different prices to different customers for the same goods, based on that person's prior, used car salespeople certainly offer different prices based on various features of the customer. So they note that this is a kind of algorithm in the brain, as they describe it, and platforms use software to implement these kind of decisions about how to distribute pricing. Now, one of those things, by the way, the Chinese algorithmic guidelines actually outlaw price discrimination algorithms, ones that would offer the same good to different people at the same for different prices. So I think this anonymous attendee says, do you think algorithmic regulation law should be applied equally to algorithms in the human brain and algorithms implemented by software?
Oh boy, that's a question we could have a long debate about. I think the short answer is that that merchants offer different prices to people all the time, and one of the things that's good about the freedom of the press is that it's possible to write a news story that will say this, and then people will get really upset. And so one of the questions I think that policymakers have to grapple with is, when can the market or when can things other than laws shape behavior? And it seems to me that that's something that again, sunlight actually might be a good solution to the differential pricing things. But we, I think, think about how airlines do pricing, right? One day this particular flight's going to cost you $550, and the next day it's going to cost you $1,500. It's the same seat, and they do it all the time. And it does seem to me that that's actually something we've learned to live with. But again, the sort of, to the extent that it became a deceptive practice, it would seem to me that consumer protection authorities, the Federal Trade Commission or the like, could take some steps, but I'm not sure that outlawing different prices is going to be something that is really something that would stand up.
Thank you, Professor Samuelson. Professor Sun, could you tell us a little bit more about the kind of concerns that you have about trade secret? As you rightly point out, that trade secret is used by all these companies. I've been looking a lot at the TikTok kind of questions. And one of the things that the United States government is doing essentially is requiring TikTok to disclose the secret sauce, not to the government, but to a kind of third party, to a trusted US entity. So is there a way to kind of compel disclosure that we might be worried a little bit? So there's the question of compelling disclosure to whom? Should it be compelled to the public, to the government, to a third party? What do you think is the right approach?
Well, thank you. This is such a great question. I think in general, I think we could have, as you suggested, there are three options, right? So, when it comes to the overall functioning of, for example, a social media platform, I personally speaking, I prefer that the right to know algorithm could enable the government to require that the platform to disclose certain parts of the algorithm or certain functions or explanations to the public at large, because the platform, a platform like that will affects the public interest. And there is also, for example, a possibility that disclosure can be made to a governmental institution. For example, the Federal Communications Commission could be involved in this process. But this is also another option. And as you said, it could also be disclosed to a third party, institution, like acting like a trustee. But I think it really varies, and it could also be disclosed to, for example, a particular person whose interest has been harmed by the application of an algorithm for example, in a litigation, right? Okay, so the person could launch a litigation to request that the court could rule that in favor of disclosure. So I think the answer is it really depends.
Great. That would be the kind of regulation by litigation model that Professor Samuelson mentioned earlier as well. Professor Yu, you had this lovely line that the cure could sometimes be worse than the disease. I think that's a really important point. And this you raised the question about, this question has been in a number of these conversations about which entity might be invoked here. Who is the regulator in these contexts? And when I'm thinking about government regulators, I always think that the people proposing the regulation have a world where they imagine their friends being the regulator. And I wish that sometimes we would imagine regulation. We should always propose regulation where we imagine our enemies being the regulators. And so I'm just curious how you would approach that question in this context of kind of compelled disclosure and other First Amendment questions raised by the net choice cases, by the Texas and Florida social media laws, which have this transparency obligation, which, as you noted, is actually but if I were to handicap those, you began the handicapping. I really think that the viewpoint neutrality requirements are a non-starter. I don't think they get 5 votes to reverse the kind of half-century of Supreme Court jurisprudence on this question. The question about transparency, however, I think is a more complicated one, and you've seen the 11th Circuit say that some of those provisions stand scrutiny, and so it'll be interesting to see whether or not those questions because as Professor Samuelson noted, the question of transparency really turns on what are the details. It's all the question of, we've seen transparency reports all the time. Some are very helpful and some are very unhelpful. Some are just kind of marketing material. In fact, not in fact disclosure of anything that might seem negative. So I'm just curious how the regulator that might be at issue kind of interfaces with your approach.
Well, that's a great question. It's funny, Anupam, you were saying, maybe we should have, think of our friends regulating. I said, well, you're my friend, Anupam. I would love to have you do it, except I wouldn't wish that on you or anyone I really cared about. So what I would say is, in some questions about, who decides or who watches the watchers is a classic question. And the problem we have here is one, not just who, but also on what basis. So the who question really brings to an idea is nobody. The classic thing you worry about is you have an institution that's supposed to distill, to correct people's preferences, frankly. You have people's expressing their preferences and what they want to be. This really echoes of Jean-Jacques Rousseau's famous idea that he said, trust the Paris Commune, we know. All of you think you know you want something else, but you're laboring under some sense of false consciousness, so we will, to use his phrase, force you to be free. And that's sort of the boogeyman line that we can always put on any institution to do that. And on some level, it's like a democracy is the worst form of government except for all the others. You know, one of the things you can say is that, in fact, leaving it to individuals to decide for themselves has its flaws, but is it, in fact, inferior to decentralized decision-making where there's no one actor, you know, buying into Lord Acton, power tends to corrupt, absolute power corrupts absolutely. If you have an actor who can decide the right vision of speech, that's a problem. Second, even if I had the would-be philosopher king, and Haochen asked a question in the chat among the panelists, well, what about the Balkans and the posts who think that, who would want to indulge in this more consequentialist vision? Yes, there's people who won't go that route. Even then, I love Robert Post's criticism of Owen Fiss's early work, where he said, you know, you need an Archimedean point where you can stand outside the system and project back onto it what the idealized political speech market should be, because otherwise you don't know which direction to correct or how hard to correct. And if that's the case, you know, in many ways, even if you're going to go that, the criterion requires a vision of a well-functioning speech market that we really believe in strongly enough to adjust and to coercively come in and change. That I don't think when I tell people that's required, they all kind of recoil in horror and say that's too hard. And that's, you know, I understand it's hard, but that's a big problem. Two quick comments. When we talk about transparency, Anupam, I think Professor Samuelson's right about transparency. It's like, what is required of it? And, you know, two things that leap out at me is behavioral algorithms is an emergent property that happens at scale. So it's not just actually looking at what the algorithms say, you actually have to see how they behave, as with any complex system. And so we're gonna have to do not just a disclosure, but ongoing monitoring of results. And then we're gonna create a compliance regime about disclosure, which is gonna be extremely expensive, as we know, and we know these compliance regimes from some of the privacy regimes we said have a huge tax on small and medium-sized enterprises. And the one thing I'll throw out for Professor Hartzog, he has actually put helpfully into the chat among the speakers the link to the Balkan piece on information fiduciaries. Of course, he knows as well as I do, David Posen and Lena Khan wrote a response to that piece in the Harvard Law Review in 2019, and that takes a more skeptical view. So I mean, there is both two sides to this that are fully engaged, and I think that we've yet to hear the last word on it.
Well, thank you all for a fabulous conversation. I've really, really learned from each of you, and we could keep on going. I'm going to turn the microphone back to Professor Sun to segue to the next panel. Thank you.
Thank you, Professor Chander, and I thank you for showing Darby to us. And so I think we maybe we could have a 5-minute break. And is it 5 minutes enough for you, Anupam? And the rest of the speakers? Yeah, okay, that's great. And I think Professor Yu has invited us to have a break on the terrace of University of Pennsylvania Law School. I love the background image. So let's have a quick break and come back in 5 minutes for the second panel discussion. See you soon.